Please be seated. Welcome to the First Court of Appeals on a fine fall afternoon. We actually have the three senior justices of the court sitting together, which does not happen very often. We have one case on today's oral submission docket, case number 0121-00519-CV, Anita F. Kawaya versus Derek Obialo. We have appearance of counsel for the appellant.
Dylan Russell, Your Honor.
And appellee.
Derek Obialo.
And I believe we noticed it for 15 minutes aside. We'll be reserving time for rebuttal.
Sure. 5 minutes.
All right, you may proceed.
Mr. Chief Justice, and may it please the court. This court, sitting en banc sua sponte, should dismiss this appeal for lack of jurisdiction because the September 27th order was and is valid. Alternatively, this court should reverse the denial by operation of law, the denial of the TCPA motion to dismiss, because Mr. Obialo's claims against Ms. Kawaya were based on in response to her communications in or pertaining to the judicial proceedings, both the appeal and the underlying trial court case that was the subject of the appeal. Additionally, Ms. Kawaya conclusively approved the attorney immunity defense, and Mr. Obialo, as an alternative ground for reversing the denial by operation of law, failed to meet his prima facie burden on each element of his claims with clear and specific evidence. So unless the court has specific questions on other issues, I was going to focus on those 3 points.
Why don't we start with what the decision tree is?
Sure.
I have a 2-page timeline of the filings in this case, and it takes some effort to figure out exactly how we get to the final decision point. So walk us through what you think the decision tree should be.
Well, I think the swearing opinion upon which the In re Obialo opinion decided that the September 20th.
Without argument, walk us through the decision tree.
Okay. So I think the court, I'd prefer a ruling on the merits today, but I just don't think the court has jurisdiction to do it. So that would mean the court dismisses the appeal, and the trial court below would, proceed with the relief available, in fact, mandatory award of attorney's fees, and then there'd be a final judgment. And then if Mr. Obialo chose to appeal a final judgment on that issue, then we would have the court decide the merits of these issues. So that's certainly decision tree number 1. Decision tree number 2 is the court decides the merits of the TCPA appeal now, and nothing then would prevent Mr. Obialo from raising at the Texas Supreme Court, after a judgment and opinion from this court, addressing that same jurisdictional issue, even though he has argued, I think, in the alternative that the September 27th order is definitely not valid in light of, now this court's.
So you as appellant want this appeal dismissed?
Only because the worst case scenario would be if this court were to take the case, decided on the merits in our preferred way, which is to reverse the denial by operation of law, send it back, and again, there's an award of attorney's fees and sanctions, the claims are dismissed, there's nothing left, it's a final judgment, and then on appeal, whether there be an opinion that comes out from the Texas Supreme Court addressing the COVID orders authority to allow courts to retroactively extend deadlines, or there's a change of heart on these issues about whether a trial court does in fact have jurisdiction after the 30-day deadline to grant a TCPA motion to dismiss, which I think the In re Pancha Carla really closed the door on that question. And of course, that was a 2020 opinion. So we're not in any particularly great situation here as far as following the clear intent of the statute of the TCPA, which is to have an expedited process. But the worst case scenario would be to have the merits reached only to find out that this court or some other court didn't have jurisdiction to do so. So that's the concern. Otherwise, I certainly wouldn't want to dismiss my own appeal, having done the amount of work that we had. But hopefully I've answered the court's questions about the 2 potential roadmaps, and if so, I'd be happy to move on to my jurisdictional argument, and then quickly, with the time I have left, address, I think, the key points.
Why don't you go to the jurisdictional argument then?
Sure, thank you, Your Honor. So Three sentences in Pancha Carla, I think, close the door. Page 440 and page 540 and 541, three sentences. Quote, the TCPA does not impose a 30-day restriction on a trial court's authority to vacate a ruling on a TCPA motion to dismiss. Second sentence, section 27005A requires a timely ruling, but says nothing about a trial court's power to vacate such a ruling outside the statute's 30-day deadline. And then page 541, nothing in the statutory scheme prohibits trial courts from vacating their own orders when they otherwise have plenary power to do so. So I think those sentences closes the door on that. However, the Morath case that I cited in that sort of 28J type letter, I think further closes the door.
Was that a TCPA case?
It is not a TCPA case, however, the language, the issue, the statute at issue there is this language in the education code that the commissioner, quote, shall not later than the 180th day after the date an appeal under subsection A is filed, hold a hearing and issue a decision without cost. So that's literally the same procedure we have here. You have to file the motion to dismiss within 60 days of service of the legal action, then the hearing has to take place within 60 days. So there's 180 days.
Do the policies and purposes of the TCPA, which are unique and probably different than the statute in that case?
Certainly the substantive policies, but
how does that weigh in terms of, is the analysis equally applicable to in a TCPA context where the statute and purposes are arguably different?
I think the expedition of the ruling is consistent between the two statutes. And here's the rule of law in Morath that I think closes the door, and that is that statutory requirements are presumed to be non-jurisdictional, absent clear legislative intent to the contrary. And there's no legislative intent that you can glean from sections 27005 and 27008 that suggests the failure to rule within 30 days is a jurisdictional bar to the trial court reconsidering an otherwise interlocutory ruling. And here's an example of a statutory clear intent to create make a requirement jurisdictional. Section 33.034 of the Code Construction Act.
Let's go back to Pancha Carla. I mean,
Sure.
one of the tensions in crafting arguments or crafting opinions is that the questions are cases bits and pieces of language that you can use and tinker with and move around, or do they actually stand for principles? And one way we would look at a procedural case like Pancha Carla is it in the same posture? Now, is the Pancha Carla posture the same as the posture here? For instance, did the Pancha Carla court have the ability to go back and change its earlier ruling?
Yeah, Mr. Obiala brought up in his response brief the factual difference between this case and Pancha Carla, and that was in Pancha Carla there was a timely ruling. However, in other words, there would have to be some text in the TCPA that allows a trial court to have jurisdiction after the 30-day deadline to modify its rulings, but only when the trial court, by written order, denies a motion to dismiss. That makes no sense. That if the trial court were to sign an order denying a motion to dismiss on the 30th day after the hearing, that would be a timely ruling. Yet in that instance, if you can distinguish Pancha Carla that way, the trial court would then have plenary power to revisit its rulings, or could rule after that 30-day deadline. But in the instance where the trial court decides, or for whatever reason can't get around to it and lets the denial happen by operation of law, that somehow that bars the trial court's authority to grant.
Well, how does that do violence to the statutory language?
Well, there is no statutory language that says that it's a jurisdictional deadline. However, what is clear from the legislative text of the TCPA, and this is brought out in Pancha Carla, that there's an intent to have an expedited process, right? And so there's nothing expedited about the process that occurred in this case, in the sense that if it's a jurisdictional deadline that ends after 30 days, then that means the appealing part, the losing movement has to take the appeal and complete that appellate process, including because there's a statutory stay, has to complete that appellate process even if the trial court below wanted to grant the motion. We know she did in this case. And here's the other thing I would say.
To reach that conclusion, don't we have to go against prior president of this court?
You do, and that's why I started by saying the court would have to take this matter up sua sponte en banc, as the court can do. But I wanted to...
Is that the Aquarian case you're referring to?
The Swearingen case, yes. In that case, the court did not cite, by the way, to Pancha Carla, did not cite to the proposition of law that I just referenced from Morath, which is absent clear legislative intent. Statutory requirements are not presumed to be jurisdictional; they are non-jurisdictional.
So just in terms of limited horizontal stare decisis, are we bound by our previous panel's decision?
This panel is. That's why the only way that I'm aware of for the court to change its mind about this is to take it up en banc. And I know the court rarely does that. I think it may do so more often sua sponte than it does on a motion.
So they do across the hall, but not necessarily here. But the parties would have the opportunity in a due procedural process to move for en banc rehearing if we were to follow our own prior precedent.
I'm sorry.
If this court, acting through this panel, were to follow the prior precedent established by Swearingen, the parties would then have the opportunity, if they wanted to, move for rehearing en banc.
That's correct. Yeah, and I didn't want to move to do that until it was necessary to do so. And I see my time is up. I'm happy to address some of the merits issues in my rebuttal time.
You have any further questions?
Good, appreciate it.
Thank you for your argument. Mr. Roviallo.
May it please the court? I'm going to start with the court's decision in.
Before we get into that, I'm going to ask you the same question. What's your decision tree that you think the court should follow?
I think the court should dismiss this case. It has jurisdictional issues in it, and I think the appellants haven't met that jurisdictional bar. They should dismiss it in the first place because this is a second appeal. It's a second impermissible appeal of a TCPA motion. They appealed the first the denial by operation of law. They dismissed it. The court issued a judgment and a mandate. Once a TCPA motion has been dismissed, has been appealed and dismissed, the trial court no longer has jurisdiction anymore. And that's in Inwood. It's one of the this court's decision. Now, they filed a second appeal of the same order. It's impermissible. That's done. And the court says the several cases that I cited, the Supreme Court said that's moot. One of the cases, it's in my motion, where the appellants and the appellee dismissed the case, and then the court later on issued a judgment. He went up to the Texas Supreme Court. The Supreme Court says, no, the judgment is moot. The case is moot because of the dismissal. And that's the same thing that we find here. There is a jurisdictional bar that they haven't, they're not going to be able to surpass, which is this second impermissible appeal. You only get one bite at the apple. I know the first dismissal was done without prejudice. That's what they're going to argue. However, the mandate had issued. They didn't recall the mandate. There's a process to recall the mandate. They didn't ask for the judgment to be re-reviewed, and they didn't appeal it. All this precluded them from filing a second appeal of the same order. Now, in Panchakala, he got it all wrong. The court is correct in their decision. And Justice Kelly, your question was proper, which is the distinguishing thing in Panchakala is that the court says a timely ruling preserves the trial court's jurisdiction. Timely ruling, whether to deny or to grant. That's what preserves the trial court's jurisdiction on the TCPA case. If the court does not timely rule, they will lose their jurisdiction. And the court actually says, unlike those cases the Court of Appeals relied on, this is the Texas Supreme Court, making a distinction between those cases where the lower court had relied on, where they relied on the one that there was no timely ruling. In Panchakala, there was a timely ruling which preserved the court's authority, and that's why the Texas Supreme Court had to reverse it. In this particular case, there was no timely ruling. And that's the right distinction between those two cases.
So what does this court have the authority to do right now? I mean, if we dismiss the appeal, do we dismiss with prejudice to refiling, or do we even have the ability to do that? Do we remand it to the trial court for further findings, like assessment of attorney's fees? What are the viable courses of action for us?
I think the proper course of action is a dismissal with prejudice, because the court does not have jurisdiction in the first place. The time has passed. That case, like the mandate that I filed, and the judgment referred to the fact that the judgment of the TCPA motion had become moot, and that was the argument in the trial court in the second hearing. That TCPA motion is no longer justiciable. It's now moot. It was appealed, it was dismissed, it's done. The second jurisdictional issue that they have, Your Honor, is the fact that there was an earlier dismissal of this case, and we're actually here for every hearing of that dismissal. Because of that dismissal, we took actions that are in reliance on that dismissal, which attach prejudice. And because of that, we think the case has become moot, and the court should dismiss. I also have a case that I cited in my brief, the Texas Supreme Court, the same case that I just made reference to, where the parties filed a joint motion to dismiss. The court went ahead and made a ruling, and Texas Supreme Court said, of course, one of the parties liked the ruling, and that's why it became an issue. I took it up to the Texas Supreme Court. Texas Supreme Court says no. Once you file a motion for dismissal, and there's an agreement to it, which agreement can come by the way of an action, which you take in reliance on the party's dismissal, that case is no longer justiciable for the court, and it's moot. So I think on that second prong,
Let's say we navigate this procedural thicket, and we actually get to the merits of the question of whether the TCPA applies to this, or in particular, whether the attorney privilege, the litigation privilege attaches, and that there is no cause of action, no viable cause of action. Why don't we address the substance of that?
Sure. We don't think the TCPA applies to this case, primarily because in the Walker versus Blumenberg case, which is a case that actually appealed to this very court, and the court made a reference to the fact that the protected activity has to be the main ingredient or a fundamental part of the challenged legal action. In this case, the fundamental act and the main ingredient is the communication from Kawaja to my former client. That's the basis of this action against her.
So wouldn't that just fit, or could you explain why that doesn't fit within the definition of exercise of the right to petition under the TCPA? Because
there are certain distinctions that were made between an action where the 2019 amendment made a distinction and removed the word, I think it says related. Now it has to be based on. The communication to fire opposing counsel is not related to a judicial action. It doesn't advance the judicial proceedings. It doesn't in any way help the other client. It's not a related, it's not a communication in the judicial proceeding. Furthermore, the underlying case in the trial court was over. So it wasn't as if the communication was done in the trial court. Now, there's no need for that communication to be done in the Court of Appeals, because at that point, the case has already been submitted to the Court of Appeals, or rather, we had received a letter saying that the case will be submitted. It had been fully briefed. So that communication, it's my submission and my opinion that it's does not in any way relate to her right to judicial, to petition under the TCPA. And it's distinguishable from the actions that I summarized in my lawsuits that she took. Those actions were only there to demonstrate the context and to provide bearing on what the consequences of what she had said now happen. For instance, her filing of a motion in the Court of Appeals. I don't think there was no basis for an action based on those filings.
Well, it seems the Supreme Court has expanded it. I mean, earlier I used the phrase the litigation privilege, but it's almost like a lawyerly privilege. As long as the attorney is doing something related to legal work for the client, then it's privileged. And this sort of relatively recent expansion would seem to preclude the cause of actions you assert.
I'm sorry, could you?
Well, the Texas Supreme Court's expansion of the litigation privilege to actually just be sort of a lawyerly privilege, as long as you're engaged in legal work for your client, that would seem to preclude your causes of action, because the actions were taken in pursuit of the client's, a lawyer doing lawyerly legal acts on behalf of a client.
Right, but I'm assuming you're referencing the attorney immunity defense that they
right.
had. Right. Now, we know, and more recently, the Landris case just came down, where the Supreme Court said that the same thing, it was a lawsuit, and they said this action is not protected. Because once the action is not part of a lawyer's duty, in other words, it's foreign to the lawyer's duty, which this one is, procuring a firing of opposing counsel, that's none of the lawyer's duty. And it's not part of the scope of a lawyer.
Well, does it advance the client's interest?
It does not advance the client's interest. In no way will it advance the client's interest for an opposing counsel to be fired. Especially in the posture that we were. Remember, this is a time when the trial case was completely over. There was an appeal and it has been completely briefed. And we were just waiting for submission and ruling. In no way, even if it was during a trial court case, it was during trial, firing that attorney will not advance your client's interest. Hopefully I've answered that. And I think the Landris case is right on point. If you look at the facts of the Landris case, where it went up to the Texas Supreme Court, and the Texas Supreme Court had to reverse and say this is not the kind of action that we would like to protect. Now, I would like to also address the fact that this court, I know that the court has already ruled on my motion to ask that their notice of appeal was late, denied their extension. They have made a motion that to permit their notice of appeal because it was filed, I believe, the last day of the 15th day after the 20th day. The reasons that they provided, and pardon me, because the panel has ruled on that case, on that motion. The reason why I'm bringing that up is after you ruled on that motion, that was when the swearing case and then Inri Obialo invalidated the order that they waited to procure, which is the September 27 order. And the whole reason for waiting past the deadline was to strategize to get this order, which we now know is void. They waited to get a void order. And in the same, and this court and the 14th court has ruled that when an appellant does that in prior cases, that they have ruled that's an unreasonable explanation for filing that notice of appeal.
Is there controlling Supreme Court authority on that?
No, I didn't find any, but I found similar cases in other jurisdictions, and the case in
Other jurisdictions like Tyler or like Arizona?
yes, Tyler and pardon me, let me. And this court had ruled in Hykonen versus Baker Hughes. That was the 14th Court of Appeals, 2002. Also in White versus Second Baptist, this very court, the first district court, ruled that in similar cases when the appellant in those cases had, I think one of them had waited so that they would run out of the trial court's jurisdiction so that they don't invoke the displeasure of the trial court. The other one waited until they procured a favorable order. Those are similar cases where the court had ruled that that's an unreasonable explanation. There's also a case from Polk versus Dallas County. That's Dallas from Dallas, and Crossland v. Crossland, 2006 case, where the court said that appellant waited for trial court to hear a motion to amend the judgment. That was a reason for waiting to file late. And I submit that in this particular case where they waited consciously, and this was in their motion, they weren't hiding their intent. In their motion, they specifically stated the reason why they're waiting is so that they can procure the September 27th order, which we now know is void. They could have gone ahead with their first appeal. And one of the languages that they brought up in their brief was that there was a unique situation that was caused by the procedures that developed in the trial court.
So on that point, we basically just have to disturb our prior ruling on the extension of time, right?
Yes.
Yeah.
There was no unique situation.
So we got it wrong?
Well, you didn't get it wrong based on the facts at hand at the time. Because after you had ruled, that's when I filed the mandamus, and this court had ruled that that order was void. So in effect, they waited to procure a void order. And that's the only difference. And I think because of that, the court should rule that it was an unreasonable explanation. Thank you.
Are there any further questions?
We're good.
Thank you, Mr. Aviala.
Thank you.
I'm going to ask you at the very beginning, if you could just jump right to the eternity immunity issue.
That's where I was
Unless
going
the
to go.
panel chief feels differently.
Not at all.
I was going to go right there. Thank you, Your Honor. This court can take a two birds with one stone approach as to both the attorney immunity issue, which will also at the same time addresses the failure to meet the prima facie burden. There's 6 pages in the clerk's record which comprise the key pages of the original and first amended petition, and then the Obialo's affidavits, the March that was filed with the petition, and then the July that was filed in support of the response to the motion to dismiss. 6 pages, 14, 15 of the clerk's record, 31, 454 to 455, and 592. And what those pages show are some paragraphs that specifically reference communications by Ms. Khawaja, and all they do is show that Ms. Khawaja allegedly communicated with Mr. Brown, Mr. Obialo's potentially former or potentially still existing, maybe for a week, client, Mr. Obialo's client, Mr. Brown. So at worst, she communicated in violation of 4.02. This court in the many examples, Luong versus McAllister is a case. The Westlaw page is 2018, the site is 2018 Westlaw 3651103. I cited the San Antonio Court of Appeals opinion for the same proposition, that you do not create a cause of action by mere violation of an ethical rule. But I think the controlling case for this court was Chief Justice Adams' opinion in the Jetal versus Johansson. I called it Ballasis, who was a co-appellee, my former partner. That opinion addresses a very similar situation where there was a claimed interest, in that case a title company. Here there's a claimed contingency fee interest in the money that was held on security, but if you, as appellate security while the appeal was proceeding. But all that those communications show with respect to Ms. Khawaja is that she was trying to negotiate or facilitate the settlement of the case, which would come to fruition in the form of the release of the judgment and dismissal of the appeal, which of course this court did without opposition, at least proper opposition, by Mr. Brown when Mr. Obialo, when called out about him claiming still to represent Mr. Brown, then withdrew, citing his the January 20th, 21 termination email by Mr. Brown. But the bottom line is all of those communications, even if wrongful on the part of the suing group, were done in furtherance of and on behalf of Ms. Khawaja's clients, the suing group. And so they're absolutely barred by attorney immunity. For the same reason, I think when you go to the two key claims, conversion, well, the court can look to Chu versus Hong, which was cited in Mr. Obialo's brief, which is another example of an attorney immunity situation. And the court made clear, this is a Justice Brister opinion, made clear that for you to have a specific interest in particular cash, it has to be specific, and it has to be held in trust. Here, the appellate security was held in trust for whom? For Mr. Brown as appellate security in the event the appeal on the merits was unsuccessful. It was not Mr. Obialo's interest in those funds. His right, potential right to those funds would be based upon the four corners of his contract with his client. And there's a case from the Texas Supreme Court called In re Davenport. The site on that is 522 Southwest 3rd 552. And in that case, a party's making a claim to an interest in certain property, and the court construes the contingency fee agreement to conclude the only thing, as I think is most typical in typical contingency fee agreements, is you have the right as the contingent attorney to recovery of any funds or sums that are recovered.
So if we agree with you on the attorney immunity issue, if we go with you on that hypothetically, what would be our disposition in this case?
If you agree on that, and assuming the court also, I think, easily could have reached the conclusion that the lawsuit was, the claims were based on response to the exercise of the right to petition, those communications that are also referenced in those same pages of the record that I just mentioned, the same 6 pages, then the court would reverse and render on dismissal of those claims and remand so that the trial court below could award the mandatory award of attorney's fees and a potential discretionary award of sanctions, as this court affirmed in both Jetal cases, the Hoover-Slovacek case and the Johansson case. So that's what we would ask the court to do if the court is not inclined either now or if there were a situation with en banc and dismiss the case, then we just have to revisit those merits issues, unfortunately, in the event there were a final judgment appeal by Mr. Obialo.
So it's those 6 pages we need to pay attention to if we want to reach the merits.
6 pages, I think, address both whether the first step of the TCPA, whether the communications are based on a response to a communication in or pertaining to a judicial proceeding. The judicial proceeding clearly includes the appeal that was still pending in January and February and March of 2021.
So how long have we this court had those 6 pages?
I mean, they've been in the record since the clerk's record was filed.
Right.
Yeah. So this 6 pages has been before the court
right.
since the beginning, and all I'm saying is those are the pages where the court can look to essentially reach each of the 3 stages. Does the TCPA apply to the communication? Is there a defense? Is there prima facie evidence? And those pages are key because they focus on what Ms. Khawaja communicated allegedly, and the court can take them as true, even though we have evidence that refutes some of those or disputes some of those allegations. Taking all of those statements as true, as I think this court must, in its de novo review, the court will find all 3 stages are met: our conclusive defense and the failure of Mr. Obialo to meet his prima facie case of clear and specific evidence.
Thank you, Mr. Russell.
Thank you, Your Honor.
Any further questions? We have the parties' arguments. The case of Anita Khawaja versus Derek Obialo is submitted, and the First Court of Appeals is adjourned. Thank you.
All rise.